Assalamualaikum and a very good day. If it pleases Yang Arif, my name is Latifah Rabbaaniah binti Jamaluddin. I am representing the respondent Pro 3 Seket Sendian Berhad. Together with my co-counsel Ms. Farahanim binti Shahruddin, and on behalf of the appellant Man Mantoya, which are being assisted by my learned friend Ms. Wan Nur Hafizah binti Wan Junaid and Ms. Shafiza binti Abu Bakar. If it pleases Yang Arif, I should start by outlining the grounds of submission that will be submitted by us on behalf of the respondent Pro 3 Seket Sendian Berhad. There are 4 grounds of submissions that are put forth all together. I will present on the first and the second grounds, which are: the first one is whether or not the trial judge court has made mistake to deny the award of damages to be given to the appellant, and second, whether or not the principles of Act Shall School Rule applicable in this case. The third and fourth grounds of the submission will be presented by my co-counsel, Ms. Farahanim. They are whether or not the defense of Valentine non-fit injuria stands in this case, and fourth, whether or not the principle of res ipsa liquita applicable in this case or not. Now, if it may pleases this court, I should proceed with the first submissions by the respondent. Whether or not the learned trial judge has made an error in denying the award of damages to be given to the appellant, Man Mantoya, in this case. Yang Arif, the trial judge has not made any mistake in denying this award to be given to the appellant on the reasons that, first, although the damages inflicted on the appellant may be caused by the respondent, but it is no greater harm than the harm that is already suffered by the appellant in the previous misadventure. Second, prior to the second accident, which was alleged to be caused by the respondent, the appellant already suffered a serious injury due to the first road accident, which had caused the appellant to permanently paralyze from his waist down and confined to a wheelchair. Third, although the second accident had caused the appellant's leg to be amputated, the fact shows that the legs could not be used and permanently paralyzed. All this reason shows that the injury suffered by the appellant is no greater harm than the injury that he has suffered in the first accident. Yang Arif, I support this argument by referring to the case of Farah Ahmad Naji, As-Sahaf, and Dr. Lee Weng Seng and others in the year 2017, Malayan Law Journal at page 172. Plaintiff in this case was a 6-year-old girl. She went through a heart operation. However, due to the negligence caused by the defendant, the doctor, the trial judge has awarded 400,000 to the plaintiff as general damages for plaintiff lost, pain, and suffer. The rationale of this judgment is because if the defendant do his job properly and prevent any medical negligence while conducting the heart operation, the plaintiff could have enjoyed her life as she did before. Thus, the same thing goes to the appellant and the respondent in this case. The appellant, Man Mantoya, would not have to suffer injury and to amputate his legs if the respondent, Pro 3 Seket Sendian Berhad, as the car racing event organizer, follow the standard rule of safety and prevent any negligence. This thing will not be happen. However, since the appellant already suffered a severe injury due to the first accident and could not utilize both of his legs, thus the negligence that may be caused by the Pro 3 Seket could not be considered as fully responsible to rectify this situation. The harm suffered in the second accident is not greater than the harm suffered by the appellant in the first accident. And due to these reasons, it is submitted to the learned trial judge that did not make any error in denying the award of damages to be given to the appellant in this case. Now, if it may pleases this court, I will proceed with the second grounds of submissions. Whether or not the principle of actual schools applicable in this case. Actual schools principle is a principle used to protect people with pre-existing vulnerabilities, or in a situation where the injury is foreseeable to be inflicted to the plaintiff, then the defendant will be held liable for causing such injury. In the case of Chong Fat Zi mentioned Sendirian Berhad and Hotel Continental Sendirian Berhad in the year 2011, Malayan Law Journal 4 at page 354. The judge has held that once the foreseeability of damages is satisfied, the defendant is obliged to be responsible for the damages that had been inflicted to the plaintiff. So, applying the similar principle in our current case, we could not use the actual school principle in this case, as the risk of injury in this case is not foreseeable. First, as a previous car racer and a technical advisor, the appellant must be aware that a car will come in to a pit stop anytime. So, in his situation and condition, he should take care of his safety first. Second, the appellant advised as a technical advisor will only be needed after a car racer stopped his car at the pit stop area. So, appellant should not be in that area before a car has come in. Third, the respondent, as the car racing event organizer, will not put their attention at the incoming car drove by the racer at the pit stop area, as this area is a well-known area to stop a car. The accidents happened to the appellant on that day is too remote to say that it is foreseeable by the respondent. Thus, we submitted that the actual school rule is not applicable in this case. Young Arif, if I have no further assistance to Young Arif, that is the first and the second submission I have made on behalf of the respondent. The third and the fourth submission will be submitted and proceed by my co-counsel, Ms. Farhanim. Thank you.